Hello friends, in this video we will discuss when does the property in goods transfers from seller to the buyer. Now property here means the ownership. Now when this property will be transferring from the seller to the buyer, it depends upon the nature of the goods. As we have done, there are specific goods, certain goods, uncertain goods. So depending upon the nature of the goods, the property will transfer. Let us first discuss regarding identified and ascertain goods. Now where the goods can be identified and ascertain, Section 18 of Sales of Goods Act says that the property will transfers as and when these goods are ascertained. The goods may be ascertained by the buyer or by the seller. The moment the goods will be ascertained, the property will pass. Second comes when the ascertainment depends upon some act. Sometimes the goods are to be ascertained, like you have to separate the goods from the bulk, or maybe you have to weigh the goods, there has to be some measurement of the goods, or some similar process has to happen. So in this case, the property will pass from the seller to the buyer as and when this act has been done. The third case is when the property will transfer according to intention of the parties, when buyer and the seller express or imply their intention for the transfer of property, accordingly the property will transfer. So Section 18 states that this provision, Section 19 states that this provision will apply only in case of specific and ascertain goods when the parties express their intentions, so accordingly the property will transfer. Now this intention can be express intention or it can be implied intention. The provision of express intention has been discussed under Section 19 subsection 1, which states that parties can expressly decide the property will transfer on this date. Accordingly, the property will be transferred from the seller to the buyer. While the implied intention has been defined under Section 19 subsection 2, which states that sometimes the parties do not expressly mention regarding the transfer of property, but this intention can be implied from the terms of the contract, from the conduct of the parties, or from the circumstances of each case. So this intention can be expressed, this intention can be implied. According to the intention, the property will transfer from the seller to the buyer. Now sometimes the party's intention is not clear. The parties are not giving any sort of intention. In that case, the law intervenes, the provisions of Sales of Goods Act will apply. So when the intention is very much clear, Section 19 will apply. But when the intention of the party is not clear, in that case, this Section 20 to 24 will apply, which is given under Sales of Goods Act 1930. Now let us see what are these Section 20 to 24. Now these sections discuss some rules regarding the transfer of property. Section 20 defines the specific goods which are in deliverable state. It means the goods are ready for delivery. Section 21 defines the specific goods which are not in deliverable state. It means they have to be still designed in the deliverable state. Section 22, it discusses the specific goods where price has to be determined. Section 23 describes about the uncertain goods which have to be still ascertained. And Section 24 discusses the goods which are sold on sale or return basis. Now let us discuss these sections one by one. Now Section 20, it deals with the specific goods which are in deliverable state. Now this section will apply when these conditions are fulfilled. There should be a contract to sell the specific goods. This contract should be unconditional contract and the goods should be in deliverable state, as we can see from this heading. So we have taken out these points. Now what does this section say? That when the goods are of specific nature and they are in deliverable state, the property in the goods will pass on from the seller to the buyer as and when the contract is made, because goods are specific and they are ready also for delivery. So whenever the parties are making the contract, irrespective of the fact whether payment has been made or not, whether the goods have been delivered or not, that hardly matters. It means the ownership is going to transfer immediately when the contract is made. Now let us see example related to this. Lucky contacts to buy chairs from the furniture market. Now he selects the chairs before making the contract. Now when the chairs have been selected, it means the goods have been specified and the contract has been entered into. But when the chairs were loaded on the truck met with an accident. So all the chairs got destroyed. Now who is going to bear the loss? Of course the owner is going to bear the loss. Who is the owner? So we are saying when the goods are specific, they are in deliverable state, the property or the ownership is transferred immediately when the contract is made. So here Lucky will have to suffer the loss as he has become the owner of the good as and when the goods were specific and they were in deliverable state. Next comes section 21. This section deals with specific goods which are not in deliverable state. So to apply this section, these three conditions should be fulfilled. There should be contract of sale of specific goods. The sale should be unconditional and the goods should not be in the deliverable state. So if the goods are not in deliverable state, when the property will transfer? The property will transfer from the seller to the buyer when the goods are put in the deliverable state. The moment we make the goods prepared in the deliverable state, the property is going to transfer from the seller to the buyer. The fact that goods have been in deliverable state must be informed to the buyer. The moment the goods have been made in a deliverable state, the same thing should come in the knowledge of the buyer. Now this information can be given by the seller, it can be given by a third person, that is immaterial. The point is the buyer should know about it, that goods are being in the deliverable state. Now let us see one example. Mona has contacted to buy 10 bags of sugar. Now 6 bags were filled in front of Mona, but the remaining bags were not full. So now a fire broke out. Of course, as 6 bags were in deliverable state, so Mona will have to bear the loss of 6 bags, while the loss of remaining 4 bags will be taken by the seller as they were not in the deliverable state. Now third point comes when the goods are specific nature but yet the price has to be determined. Now price of the goods is not fixed but the goods are of specific nature. Now this section will apply where these three conditions are fulfilled. Goods are of specific nature, goods are in the deliverable state, but still something has to be done to ascertain the price of the goods. Now this something can be weighing the good, measuring the good, testing the goods, or any other thing has to be done on the goods. So in this case, when the property is going to transfer, the property will transfer from the seller to the buyer when this act may be weighing, measuring, testing. As soon as this act has been done and the price is ascertained, the property is going to transfer from the seller to the buyer. Now let's see one example. The buyer contracts to buy 10 quintals of oil at the rate of 2000 per quintal. Now seller has weighed 3 quintals of oil and delivered them to the buyer. The buyer paid for 3 quintals of the oil. The ownership of remaining 7 quintals shall be transferred only when it will be weighed. So here weighing the product was the act that has to be done. The moment that weighing will be done, only then the property will be transferring from the seller to the buyer. Next comes section 23, which describes about the unascertain goods. So in case of unascertain goods, the property in the goods will transfer from the seller to the buyer when the goods are ascertained. But the ascertainment of the goods should be unconditionally appropriated by the seller. It means seller will not attach any condition. It should be unconditionally appropriated. Appropriated means it can be weighed, it can be packed with the assent of the buyer, and must be the same goods about which description was given by the seller. It means the seller cannot provide some other goods. The same goods should be provided. So as soon as the goods will be ascertained and it should be appropriated unconditionally, the property in the good will pass from the seller to the buyer. Now let us see one example related to this. So there was an exhibition of painting. So the painting was selected by the buyer. It means the good were ascertained and the painting were tagged as being sold with the name of the buyer. The moment the buyer selected it, the seller has put up a tag on it that this belongs to person A or B. So we can say that paintings have been appropriated in the favor of buyer. Another example can be Ramesh contacts to sell 10 kgs of sugar to Geeta All the sugar belonging to Ramesh was lying in the warehouse of Messrs. Kailash. Ramesh intimates Messrs. Kailash that 10 bags of sugar were in the name of Geeta. So what does Messrs. Kailash has done? He deletes the name of Ramesh from those bags and enters the name of Geeta on those bags. So it means the goods have been very correctly appropriated. So here now Geeta will be responsible in case of any loss. Now fifth point deals with section 24, when the goods are sent on sale or return basis. Sale or return means the goods are given to the buyer for a trial. If buyer likes it, he will keep it, otherwise he will return it within a specific time. So when the property is going to transfer in this case. So now when the goods are sold by the seller to the buyer on approval basis, so it is a conditional sale. So when the condition means the buyer will be satisfied, he will keep it, otherwise he will not keep it. So in this we are going to discuss about three cases. Express acceptance. If the buyer tells the seller that I like the product, I am going to keep it, the property will immediately pass. So if the buyer signifies that he has accepted the goods, the property will immediately pass to the buyer. Let us see one example. C takes a car from Q on 15 September on approval basis for 3 days. So he tells that I will try this car for 3 days. If I will like it, I will keep it. But on 16 September, C informs to Q that I liked the car and I am going to keep it. It means the property in the car will transfer on 16 September itself. Now you will not wait for 3 days. So whenever the express acceptance has been given, the property will be passing immediately from the seller to the buyer. Now second point comes implied acceptance. Here the buyer does not expresses as in the first point, but the buyer does some act which shows that he has accepted the goods. So the buyer can resell the goods further, he can pledge the goods. So it will show that he has accepted the goods, even though those days have not expired for which sale or return basis were done. Let us see example related to this. Ashi took a car from Ramesh on sale or return basis and she said that I will try this for 4 days. But Ashi did not reply about her acceptance or rejection or keeping the car. But she pledged the car to a third person. So it was held that pledge means this is an implied acceptance. So Ashi has taken the car. Now the third point comes retention of the goods without approval. Now when the buyer does not say anything about his acceptance or rejection, but he retains the goods without giving notice of rejection, so it is accepted that the goods have been accepted by the buyer, the ownership has been transferred. Let us see one example. A took a car on approval basis from B for 3 days and A neither informs the buyer about the acceptance nor rejection, but he does not return the car even after the expiry of these 3 days. So after the 3 days, it is very much clear that A has kept the car and A has become the owner. So these are certain cases where we have discussed regarding when the property will be transferring from the seller to the buyer. There can be express intentions, but when the parties are not expressing anything, in that case the provisions of section 22-24 will apply. Thank you.